Hello. Welcome to Teaching American History Saturday webinar, a webinar and podcast series that explores controversies of American history. Today we are joined by our host, Jason Stevens of Ashland University, and panelists Scott Yenner of Boise State University and Andrew F. Lang of Mississippi State University. For this month's controversy, we've chosen to focus on the 14th Amendment, an amendment so ambiguous that 2/3 of all Supreme Court cases incorporate its interpretations in their decisions. So, should the passage of the 14th Amendment be considered the fulfillment of the Declaration of Independence, or is it a new founding?
All right, good morning, everybody. My name is Jason Stevens. I'm Assistant Professor of Political Science and History at Ashland University in Ashland, Ohio. And I want to welcome all of you to our October episode of this year's Saturday webinar series, American Controversies. We've been talking about fundamental questions in the history of the American story that involve significant constitutional, social, moral, political questions. By bringing together thoughtful scholars, like the two gentlemen who are joining us this morning, by bringing together thoughtful scholars with a variety of points of view, we hope to have a discussion, a conversation about historically important issues that still resonate in the current classroom. We encourage all of you joining us today to participate in that conversation. We want you to be a part of this discussion this morning. And we'd like you to do that by submitting any questions you might have for our panelists. Please use the Q&A box, not the chat box, but the Q&A box to submit your questions. And we will try to get to as many of those as possible here this morning. And then within the next week, you will receive an email with links for further reading, as well as a link to the archived video from today's program. In the registration form, we linked to the speeches, the letters, the other writings that we are using for today's conversation. I've got to tell you, these are great documents that we're going to be looking at today. I encourage all of you out there to read them. Many of them are also available online at the Teaching American History's extensive document database located at tah.org or in our core document collection. Today, we will be discussing the 14th Amendment. Joining me on our panel is Scott Yenner. He is Professor of Political Science at Boise State University, as well as Andrew Lang, Associate Professor of History at Mississippi State University. Both are also longtime faculty members in Ashland University's master's program in American History and Government. They're both good friends of Teaching American History in the Ashbrook Center. And gentlemen, I just want to welcome both of you to our webinar here this morning. Thanks for doing this.
Thanks for having us, Jason.
Indeed, thank you very much.
I don't want to worry about just dipping our toes in the water here. We're going to go ahead and jump right in to this American controversy. Today, our guiding question is this: did the 14th Amendment fulfill the promise of the Declaration, or was it a new founding? Scott, Andrew, I'd like to begin maybe just by asking one or maybe both of you, can you provide some framework? What is that question asking? What's going on here? What exactly is our guiding question getting at? What does it mean, right? Was the 14th Amendment a fulfillment of the promises of the Declaration, or was it a new founding? Before we get started, I want to make sure we're all on the same page about what exactly it is that we're talking about here. And then maybe just as a follow-up question, can you explain for our audience why this is such an important question, not just for teachers and students to think about seriously, but really also for all Americans to think about?
Yeah, I'll take a stab at that first, Jason, and thanks for that. So, just let's go back to first principles on this question. So, according to the Declaration of Independence, the purpose of government is to protect rights. And, especially among which are life, liberty, and the pursuit of happiness. When the Constitution of the United States is passed, it extends that promise or that goal of government to the created national government. So the national government has limits placed upon it that it cannot, like pass laws against the freedom of speech. It cannot abridge the trial by jury, and so on. But it does not do so to the state governments, which are also existing at the same time in the same constitutional system. The Declaration like limits the national government, but if you want to think of it like this, the Constitution does not overly limit the state government. So the state governments are not held to the same standards of rights protection that the national government is held to. Now, part of the reason for this is the existence of slavery when the Constitution itself is passed, but it's also kind of more of a state-centered system. That is, the states kind of demand sovereignty over matters involving property regulation, travel, contracts, and free speech, free religion practice. So there's a lot of diversity among the states. They're not held to the same standards of rights protection that the national government is held to. The 14th Amendment is an attempt to deal with that problem. That is to extend, the 13th Amendment had abolished slavery. That's gone. But now the 14th Amendment is dealing with the state's regulatory capacities, or the standards to which states will be held when it comes to regulating rights. And the readings that we have show, the problem that they're dealing with. Like some states didn't allow freedmen or others to travel or have jobs or have the right to contract. And then the national government kind of steps in and says, well, that's not exactly what we wanted. So, but it requires a constitutional amendment to extend the rights protection to states, to hold states to that standard. So I think the way I look at it, the 14th Amendment question is holding states to standards of rights protection extending the promise of the Declaration, or is it like a wholly new revolution in the government? You can kind of see my answer to it in the way I framed it. I do think that it's extending the general promise of the Declaration to states, holding them to standards that are pretty traceable to the Declaration itself. But that in itself means that like it's a rejiggering of the power relations between the national government and the state governments. The debate, all right, we can talk more about it as we go forward, but that's the way I would frame it.
I think we're going to find that Scott and I are in violent agreement for the next hour or so, which is a good thing. I think that he said that quite aptly. I will add just a few things. When we think about the 13th, 14th, and 15th Amendments, in our popular imagination and popular memory of the American Civil War era, we assume that they are natural outgrowths of the reasons for which a majority of the loyal American citizenry went to war in 1861. And I think that we need to disabuse ourselves of that notion. For in 1865, most white Americans, that is, would have looked at the tally sheet and said that their two major goals and objectives set forth in 1861 had been secured. One, defeating the rebellion and eliminating secession as a political recourse in the constitutional order. And two, now this became a contingent outgrowth of the war, but emancipation as the means by which to eliminate the central political controversy that had roiled the Republic since its inception. By removing slavery also removes the basis from which any resurgent secessionist movement in the future could sunder the nation. The 14th Amendment and its spirit and its essence is not necessarily embodied in those first two objectives, insofar as we assume that the 14th Amendment deals with the question of racial equality. It does, but that is in many ways, at least contemporaneously, a secondary consideration. The 14th Amendment, if we take the architects at their word, what it's doing is it's trying to secure political equality in a region that had long been forsaken of small r Republican political equality. And why? Because between 1865 and 1868, the resurgent old Confederate political order had gotten back into power by harnessing political authority through the means of leveraging racial oppression and exploitation. That is a violation of the verdict of Union victory, a violation of emancipation. And thus the 14th Amendment, in my mind, is a conservative reaction against a revolutionary, anti-constitutional, anti-small r Republican attempt by white Southerners to infuse the nation with those secessionist tendencies, those anti-Republican tendencies. And we're left then, the basis of our question today, we are left then with what exactly is the 14th Amendment? Is it a limited document in the sense that it secures and guarantees political equality? Or is it a document that is a guarantee of absolute universal rights? And considering that 2/3 of all Supreme Court cases from 1868 until today have dealt with that question, that's why we're here this morning.
Wow, that's really, really good. And I did not know that about the Supreme Court. 2/3 of all Supreme Court decisions have something to do with the text of the 14th Amendment. So maybe it's important for all Americans to understand what exactly this amendment does, what it does not do, and why it was necessary in the course of American history. That's really good, gentlemen. Thank you. I want to encourage everybody out there in the audience to continue to send us questions via the Q&A box. Please use the Q&A box, not the chat function, to ensure that we get those. And yes, feel free to our audience, keep those questions coming. We're going to try to get to as many of them as we can. I'd like to maybe just go next. And this will probably end up getting us started talking about the wonderful documents that we had to look at today. By the way, all of those documents, Scott, I think come from your volume in the core document collection of Reconstruction. Yes, we've both got it right there. This is a terrific volume, right? Scott has really helped teaching American history by putting this together. And the documents selected for today, as I was preparing for this webinar, I realized that they perfectly tell this story from the end of the Civil War and into the next decades of the necessity and the interpretation of the 14th Amendment. And so maybe that's where we can go next in the course of our conversation here. Fellas, maybe one or both of you can jump in here and start us off. What was the situation politically right after the end of the Civil War, right around the end of the Civil War, especially for the newly freed slaves in the South? What challenges existed for securing the freedom of the newly freed slaves immediately after the Civil War?
Yeah, I mean, one of the things that attracts me to studying Reconstruction is that I think it's actually the hardest question that's ever faced the American government. I mean, it's like nothing like founding the Constitution. That's like child's play compared to the difficulties that come up after Reconstruction, because you have two problems, and the solutions to those problems point in opposite directions. So on the one hand, the Union has won. They need to restore state governments in some way to the South. Like, they're not going to abolish the states. So they're trying to like reintegrate them into the Union after like killing each other for 4 years. Not easy to do. And on the other hand, they kind of want to go against the grain of the Southern tendencies and secure emancipation more or less for the freedmen. And so the more you restore the old Southerners to rule in the South, the less they're going to be willing to emancipate the slaves in reality. On the other hand, the more you emancipate the slaves in reality, the less you're going to restore order and political rule to the Southerners. So trying to do both those things at the same time is trying to go east and west at the same time. And so there's various models that are adopted for accomplishing this, like Andrew Johnson, who I think is one of the key figures that's laying behind most of these documents, has taken over for Lincoln as president. And his idea is like, just let the Southerners back in, let them, govern themselves however they see fit. And let's not hold them to any standards. We've abolished slavery. Make them say they're never going to secede again, and we're done. We have reconstructed the Union. And the Northern Republicans are like, no, we actually want to accomplish the emancipation of freedmen too. And so they're always trying to up the game of the national government vis-a-vis the Southern restored governments. And the Southern governments, left to their own devices, do the things in our first document. They pass the Black Codes. I just have the Mississippi example, but these could be seen from almost any Southern state. And Andrew is down there in Mississippi, so maybe he's more of an expert on the Black Codes of Mississippi than I am. But, they just restrict. Like, we've abolished slavery, they say. We have abolished slavery, but like, you can't leave the town. And you must work in agriculture. And you will work the whole year and get paid in December. And all of these things are like laws that are passed that really restrict the freedom and the ability of the, thank you, honey, the Southerners to, of the freedmen to actually live free lives. So it's that practical problem. Like, Johnson doesn't care about it. He's like, yeah, that's what self-governing states do. And the Northern Republicans, no, this is not why we fought the war. Lincoln said, at Gettysburg, that we want to fight, bring this to a conclusion so that the dead shall not have died in vain. Well, this would be vain if that's all that's accomplished. So the debate is how to hold those governments to standards of like rights protection, and not only for the freedmen, but also for white Republicans who move down there, and people who want to speak about the condition of the freedmen have been arrested in the South. So they want to extend the rights protection and limit the power of the states. But how do you do that? And the debate on the 14th Amendment is really about how to go about doing that. We'll get into that a little bit later on, because there are several models for how to do it. But I think that's the basic political situation as I understand it at the beginning of these documents.
I'll add just a few additional points. I feel like we have, I really like the image that Scott drew about goals that are at once consistent and yet paradoxical. And I think that we can see this also in what's happening to the size and scope of the United States Army between 1865 and 1866. It's the foremost federal institution on the ground in the South at the very end of the Civil War, obviously. It is the institution, federal institution, arguably most responsible for overseeing the process of emancipation in real time. And yet, between 1865 and 1866, what is happening to the million soldiers who were in uniform in April and May of 1865? It is shrinking at a remarkable pace. 1 million soldiers in uniform in April of 1865, down to 200,000 by the end of the year, down to maybe 50,000 a year later. So why are Republicans shrinking and demobilizing the very institution that can enforce the goals of Reconstruction, right? Maintaining the Union, enforcing the ideal of emancipation? Well, there's our paradox, because in order to preserve the Union itself cannot remain a highly centralized, highly militarized European-style state that is overly coercive against its defeated foes. This is one of our great problems, and yet the Army is the haven to which freed people moved for protection, for legal recourse, etc. The second problem that we have, and it relates to the Black codes, is emancipation is dead. Well, what we see happening in the spring, summer, and fall of 1865 throughout Reconstruction is white Southerners absolutely consenting to the political reality of emancipation, but they are not going to consent to what Alexander Stephens in his infamous Cornerstone speech, talking about the foundation of the Confederacy, they're not going to consent to the death of what they believe to be, quote, a natural and moral order of white supremacy. And in the white Southern mind, what is happening through emancipation, through even a modicum of discussion about political and racial equality, they see an unholy, unnatural revolution happening against civilization itself. I want to see if I can find it real quick. Jefferson Davis, when he is in prison at Fort Monroe, Virginia, in the fall of 1865, writes to his wife, Verena, and he explains this mindset perfectly. He says, if those who cannot shut their eyes to the evils involved in the social changes which have so suddenly been wrought, or vainly attempt to resist a tide which cannot now be arrested, the direction of affairs must fall into incompetent or corrupt hands, and accumulating disasters must be the result. And so what we need to do in understanding where we're headed with these debates about the 14th Amendment, we have to understand former Confederates as they understood themselves. Their reaction to emancipation, to racial equality in their mind is rational, it makes sense, it's self-evident, and that's our problem.
Yeah, Andy, you mentioned Alexander Stephens. After the end of the war, isn't he the former vice president of the Confederacy? Isn't he reelected to Congress by his constituents, and he just shows up one day, knocks on the Capitol door, and just, hey, we're back. Nothing has changed.
Absolutely. This happens in 10 of the 11 Southern states by the end of 1865. They had 10 of the 11 states, with Texas as the exception, had complied with Andrew Johnson's plan for Reconstruction, which meant, as Scott said, repudiating secession, accepting emancipation through the 13th Amendment. And that's it. Rewriting state constitutions, electing new state and national representatives. And here we see former Confederates from Alexander Stephens on down arriving in Washington to take their due seats in Congress. Reconstruction is done. The Civil War era is done. And yet, even the most moderate Republicans kind of look at this and say, no, this is kind of beside the point, right, to put it mildly. As Scott so eloquently said about Gettysburg, this has to mean something. The last 4.5 years has to have some kind of meaning. The loyal American citizenry, to put it bluntly, they're grossly offended by what they perceive to be explicit slights from white Southerners against the terms of the war. Absolutely.
And Andy, that's actually the perfect transition to our first question from the audience. So thank you for that perfect transition. I'll pay you later. Here's a question from an audience. And this goes back to what Scott was telling us about the difficulty of Reconstruction and Johnson's plans as compared to Lincoln's plans. Right. So one of our audience members says that Scott has explained the goal under Johnson's leadership, where the South was restored but not reformed. How would that compare to what Lincoln had in mind? Could Lincoln have handled Reconstruction better than Andrew Johnson? I hope so, but even a man of Lincoln's great talents may have been seriously challenged, right, by the task before him in Reconstruction. Maybe the best thing, I don't know, I don't want to be too crude, but maybe the best thing that happened for Lincoln's reputation was that he died before having to face the realities of Reconstruction. Scott and Andrew, please feel free to jump in.
Well, I've said that many times, what you just said there, when it comes to Reconstruction. I don't think Lincoln, the spirit that animated Lincoln was way different than the spirit that animated Johnson. Like, Johnson was happy with racial subordination in the South. And Lincoln, I think, was a pretty sworn enemy of racial subordination. And I think all of his comments on that are pretty qualified when he discusses it before an Illinois electorate. But I think when you actually trace what Lincoln was doing when it comes to Reconstruction, that it actually maps pretty close to with what Johnson did. He was very in favor of, like, Louisiana was like the Berlin of Reconstruction. It was the place where all the action was happening. So Berlin in the Cold War is like Louisiana for Reconstruction. All the action was there. There wasn't an airlift in Louisiana, but all the legal action really arises from Louisiana, because it was the first place that the Union conquered during the Civil War. And it was the first place where, the attempt to remake the government, I'm using a different word than restore or reconstruct, and figure out what you're going to do with the people who waged war against the United States, and figure out what you're going to do with the freedmen. That's the first place that arose as a topic. And Lincoln was for a very easy peace with Louisiana. Even after Appomattox, in his last public address, that he gives spontaneously on the balcony of the White House or something like that, Lincoln says, let Louisiana back in. They haven't done everything I'd like them to do. They haven't given the vote to blacks, which I'd like them to have done, at least the people who've served the Union cause. But we're going to be able to reform them more if we let them into the Union and let them have their own government. And we're going to really aid and succor our allies in Louisiana by doing that. So I think that Lincoln, as I say, I think the spirit that animated Lincoln was different than Johnson. He may have adapted over the course of time to the changing realities, as many of the Republicans did. And so I don't discount that at all. But from the actual evidence we have of Lincoln, he was for what I call an easy peace, with malice toward none, with charity toward all, famously said in the second inaugural. What that means is we're not going to be mean to the Southerners. That's with malice toward none. That's like toward the people who waged war against the Union for the last 4 years. We're going to give them an easy peace. He did give them easy peaces. He gave them pardon. He granted amnesty to everyone who asked for it. And so I think we only have kind of faith in Lincoln to think that he would have approached it differently than Johnson. I think it's a grounded faith. But during the war and in its immediate aftermath, while Lincoln was still alive, he showed much the same inclination to what I will say, restore the South. And not hold them to overly high standards of rights protection.
And Scott, I think I've heard you say also before, whereas Lincoln in the second inaugural says with malice towards none, with charity for all, maybe it would have been better to have it read with malice towards some and charity for most. Am I remembering this? I think this is another line of yours.
Yes, that is a line of mine. It's one of the famous lines of Lincoln, but it leads to a horrible policy of restoration that Johnson ends up adopting. And like these people waged war against the United States. Someone's got to hang. But if no one hangs, well then there's no consequences for it. So people will push the envelope for reintegrating the Union without any fundamental change in how the states behave. And that's what happened. Lincoln tried to encourage, for instance, Jefferson Davis to abscond from the country, and that would be better because that's more charitable than putting him in prison. And maybe not. Maybe the actual charitable policy is to hang the leaders of the rebellion, and then when their spirit comes to restored government, hang them. And then you might actually get fundamental change.
This is my favorite part of having a Reconstruction discussion, because inevitably, what would Lincoln have done during Reconstruction always comes up. And so I've been over the years training my response to this. I agree with pretty much everything Scott said, but I'm going to start with this. The most vocal group of Northerners opposed to punishment, overwhelming punishment against Confederates was actually the abolitionists, because the abolitionists argued that to engage in this kind of violent recourse, almost revenge, makes us, the American people, the loyal American people, look exactly like and act exactly like slaveholders. And so their argument was, what better punishment than keep them alive and free and live in a society in which every day you see how your world has been turned upside down. Everything that you once thought was right, moral, and natural is now gone. That Black men now walk equal, of course, alongside white men. That a permanent labored underclass governed by the strong-armed power of the central state is gone. So that's the argument they make, and I always find that interesting. Where Lincoln is concerned, Scott's absolutely right. That on paper, the political program of restoration between Lincoln and Johnson is absolutely almost identical. But I want to add, Scott mentioned that Johnson harnessed public sentiment in the most foul and destructive ways. I think that's the great difference between Lincoln and Johnson. Lincoln absolutely would have faced the same political difficulties that Johnson did. But Lincoln's basis and his philosophy of restoration was conditioned on the assumption that white Unionists in the South would slowly, over time, shape public sentiment in a way so as to convince fellow white Southerners of the new reality. Because this new reality can't be forced. Because when an oppressed or a defeated people, like former Confederates, are faced with force and coercion, there will be a violent reaction. And so, how do you shape public sentiment? It's hard work, as Lincoln said during the Lincoln-Douglas debates. What did he say? Public sentiment is everything. With it, nothing can succeed. Without it, nothing can fail. But it doesn't happen overnight. And when we're thinking about Louisiana, Lincoln writes a letter in March of 1864 to the, I don't know if he's the military governor, or he's at least the Republican governor, the Reconstruction governor of Louisiana, Michael Hahn. And he says, I barely suggest for your consideration whether some of the colored people may not be let in, as for instance, the very intelligent, and especially those who have fought gallantly in our ranks. They will probably help in some trying time to come to keep the jewel of liberty within the family of freedom. Well, what's he talking about here? It's the same logic that Lincoln used to advertise and support his policy for arming Black men as Union soldiers. Who better than the most loyal of Americans who support the Republican Party, who support the policy of emancipation, to demonstrate in shaping public sentiment, right? That we meaning Black men, are equal, that we are functional members of a free society, that we are intelligent. And what Lincoln means by intelligent is very key here. Not meaning smart, but meaning how do we connect ourselves to the fundamental ideals of the American founding and recognize the American founding for what it truly was. There's no group of Americans who understand the authentic meaning of the American founding, properly understood, than Black Americans, necessarily so. And so that's what we're missing in the wake of Lincoln's assassination. This subtle, nuanced, but very focused shaping of public sentiment, and the consequences are stark.
Yeah, that's such a good point. That's such a good point. Thank you both. We have another question coming in here from our audience. And by the way, to our audience members out there, please keep them coming. This next one has to do with our next document, which I believe is the Civil Rights Act of 1866. Both of you gentlemen, you've laid out very nicely for us all of these various challenges that existed in the country right after the end of the Civil War. How were those challenges addressed by legislation or some other means prior to the passage of the 14th Amendment, and how successful were they? We have in mind probably specifically this next document, the Civil Rights Act of 1866. How effective was this act of Congress, this person asked, and why then was the 14th Amendment still necessary after its passage?
Well, I look at the Civil Rights Act and the 14th Amendment should be seen kind of as a package deal. They represent a model for how to get things done, how to reconstruct the South. And I don't think it should be seen as why was the 14th Amendment possible. That's the right way to look at it, I think, is the 14th Amendment is the constitutional change on which the Civil Rights Act rests. So we had to deal with the problem that the national government was not holding the states to any standards in the Constitution. The 14th Amendment changes that reality. There are standards to which the states will be held after it is passed. And the states will be held, as Congress interprets it, to these standards that you find in the Civil Rights Act. So let me just use an illustration here for a second. Under the original Constitution, states could provide unequal protection of the laws, so that they could regulate who has access to state courts, what kind of punishments state courts mete out to the people who have committed crimes. Was completely unregulated by the national government. What the 14th Amendment does in its final form, and we can talk about the various forms that it takes because I think that's important. But what the 14th Amendment does is say, like, actually, no, states have to provide equal protection of the laws, same crime, same punishment. And then the Civil Rights Act creates like legislation to like mirror the same thing. Congress requires that people have access to the courts, to the full and equal benefits of all laws, as it says in Section 1. And I think it's explicitly toward the freedmen in that case. Everyone shall have the same equal benefit of all laws and proceedings for security of property and persons as is enjoyed by white citizens, and shall be subject to like punishments, pains, and penalties. So that means that now there is a provision in national law and an institution in the national government that will oversee the actions of state government. So let me back up and let me make that a little clearer. The 14th Amendment, as it is passed, gives people who have not gotten the equal protection of the laws access to federal courts. They can say that my constitutional rights have been violated. I have not gotten equal protection of the laws. The Civil Rights Act allows the national government to dip in to the states and say, we are now going to provide you with equal protection of laws that the states have deprived you of under the supervision of the Department of Justice. So if Congress never does anything, if it never passes the Civil Rights Act, people still have access to the courts under the 14th Amendment. But the Civil Rights Act also allows, under the Section 5 of the 14th Amendment, the national government to dip in and actually actively provide the regulation of the states that it didn't have under the original Constitution. So I look at them as like a framework and as part of the same framework for protecting rights. And like, just to make it very clear, the way I look at the 14th Amendment and the Civil Rights Act is the backstop theory. The states get the first chance of protecting rights. They always have had that, all right? If they don't do a good job, then there's a backstop. There's a backstop in the 14th Amendment and the Civil Rights Act. So it's not revolutionary in that the states always have the first stab at protecting rights. But the revolution, which is smaller than it might otherwise be, is that if the states screw up, there is appeal to the courts, and as long as the Civil Rights Act stay on the book, an appeal to like national executive institutions to provide the rights protection that it might otherwise not have had, absent these backstops. So like Johnson was like, come back in and do whatever you want. That's the restoration model. The Civil Rights Act and the 14th Amendment together like equal the backstop theory of how to protect rights.
Just a very quick follow-up to that, Scott. So without the backstop of the 14th Amendment, if you just have the 1866 Civil Rights Act, without that backstop, doesn't that then mean whichever party controls the Department of Justice, right, will determine, right, the extent to which those rights are protected by the national government? So if Republicans are in, that's one thing, but if the Democrats come in charge, that may be quite another. And therefore the protection for those rights would vary depending on who's in charge of the government.
Not only that, but if the Democrats took control of Congress, they could repeal it. So, yeah, not only would it be shaped by an executive, but it could be repealed by the legislature. And that means that there's always the backstop to the federal courts. And, you know, the document that, you know, like my favorite document in the volume that I did, if I can say that, they're all my children, but this is my favorite child, is the document on the debates concerning the 14th Amendment, which are really right on that topic. And I don't know if everyone wants to look at it, and like, can I just go for a second here and talk about this? But the original form of the 14th Amendment, if you look at the document called Congressional Debate on the 14th Amendment, all it did was empower Congress. All right, this is the original 14th Amendment. Congress shall have the power to make all laws necessary and proper to secure to citizens of each state all privileges and immunities of citizens of the several states, and to all persons of several states equal protection of life, liberty, and property. So all it did was empower Congress to make laws, but it didn't create a constitutional right. And this fellow from New York, Giles Hotchkiss, arises to oppose it. Now, this guy was like a Lincoln type. You know, he joined politics because he wanted to save the Union. He was an adherent to Lincoln. And he says, look, I mean, this original proposal, I like what you're trying to do, but it's not done very well. And he's criticizing the Ohioan John Bingham, who has written it. And Hotchkiss says this to him. You know, everyone laughs when he says it, but he says, I think the gentleman from Ohio, Mr. Bingham, is not sufficiently radical in his views upon the subject. I think he is a conservative, and everyone laughs. And but he's conservative because he hasn't created the constitutional right. And then basically, Bingham goes into his cave and studies the matter of how to protect rights for a couple months and comes back with what is now the 14th Amendment. Says, Giles, I understand what you're saying. We should have created a constitutional right. We should have said, no state shall, right? That's the formulation of the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life or liberty or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws. So now it's a standard to which states are held, regardless of who controls the levers of the legislature or the executive branch. They can always appeal to the judiciary. Now, that doesn't always end up working. We'll get to that in a little bit, but.
I'm really glad that we dipped into the debates on the 14th Amendment, because they're absolutely relevant to the Civil Rights Act and everything there between. I love the Hotchkiss argument, because the other point that he's trying to get across is to say, look, are we really comfortable with the federal government itself, the author of what the state laws will be? And that's not what's happening in the final draft, right? It's the exact opposite. Scott's exactly right. Instead of the federal government being the author, it is instead the arbiter. And that's a huge difference, because elsewhere in debates, it's not in our packet here, but these debates are so voluminous. There is an emphasis from the most radical Republican down to the most conservative Republican during these debates about the necessity of maintaining federalism, right? And in that sense, I like Scott, the premise of revolution begins to shrink. Because yes, the federal government has new authority, but does it have new power over the states? I don't think it does, because the states are still able in the federalist structure to be their own laboratories of democracy. But what is the standard to which they're held? It is nothing more, nothing less than the enduring clauses of the Declaration of Independence. Now, with the Civil Rights Act and the 14th Amendment, opponents from Northern Democrats to Southern Democrats said, well, the Civil Rights Act is, and Andrew Johnson, blatantly unconstitutional, right? It is a revolution of the constitutional order. I'm not sure, I am sure, but I was going to say, I'm not sure that that's correct. And here's why. Several things. When we look at the 13th Amendment, we often lose sight of Section 2. We always go, obviously, necessarily to Section 1, neither slavery nor involuntary servitude, ... shall be do. It bans slavery. I'm trying to do it from memory. Section 2, though, Congress shall have the power to enforce this article by appropriate legislation. That, I mean, I love the vagueness and the open-endedness of that. What is the Civil Rights Act doing? It is an outgrowth right there of Section 2 of the 13th Amendment, an amendment, of course, that is ratified by 3/4 of the states, thereby giving the people's sanction, a popular majority rule consensus sanction to the Civil Rights Act. But the Civil Rights Act and later the 14th Amendment are also growing out of a long-standing, decades-long anti-slavery constitutional tradition that is rooted in the anti-slavery reading of the last line of the Fifth Amendment. Let's see, no person, and remember, the Constitution does not specify what kind of person. It doesn't say no white person, it says no person. Anti-slavery activists argued that enslaved people, by their very nature as a person, cannot be property. And thus, in the Fifth Amendment, no person shall be deprived of life, liberty, or property without due process of the law. The Civil Rights Act, the 14th Amendment, give definition and texture to what already exists in the Bill of Rights. And so, do we want to talk about this as a revolution in democratic government? Sure. There are plenty of arguments for that. And Eric Foner, the great historian of the entire Reconstruction period, has made that case in his book since 1988. And he's got a good case. But I don't know, I just look at it different, because I read the debates, I read the context. 19th century Americans are inherently conservative, non-ideological conservative. They are fearful of revolution. They are fearful of great, massive change. They want to preserve a small r Republican system properly understood. I think that's what the Civil Rights Act and 14th Amendment are doing.
That's so interesting. That's so interesting. Thank you so much for that response. We've got several questions coming in, and folks, keep them coming, please. We're getting several here on the debates on the 14th Amendment and what the 14th Amendment actually means. And so I want to try to maybe combine a few of those before we move on to the Supreme Court's interpretation of the 14th Amendment, which I think with the Slaughterhouse cases, that's our next step. But maybe before that step, I want to go back just one more time to those debates, because one of our audience members, or like I said, several of our audience members are interested in particularly what, both of you gentlemen have mentioned this Mr. Hotchkiss, what he has said in the course of the debates. One of our audience members pulls out a great line from these debates where Hotchkiss says, "Constitutions should have their provisions so plain that it will be unnecessary for courts to give construction to them. They should be so plain that the common mind can understand them," end quote. Is he inferring, that we should be able to understand exactly what they meant should occur with the 14th Amendment, especially considering there's so much debate about this today? Andy, you mentioned at the top of our webinar, 2/3 of all Supreme Court cases deal with the 14th Amendment. So Howard, please just comment on that. Is he inferring that we should be able to understand exactly what the 14th Amendment says without much help? Or do we need the Supreme Court to figure it out for us?
I'll just briefly say, I want to advertise something real quick. This is a book that I recommend everybody read. William Nelson, The 14th Amendment, From Political Principle to Judicial Doctrine. It's published in 1988. This semester, I'm teaching a graduate seminar on Reconstruction, and this was this past week's reading. This is one of my favorite books to help us understand this question. One of the big themes that he draws out in this book, and he has looked at every congressional debate, every private correspondence, everything written by the architects of the 14th Amendment. And he says one of the great paradoxes of the authors themselves, and they knew it, was that they were writing something, what Nelson calls with emptiness and vagueness. Now, he's not being critical. It's the emptiness and vagueness that actually speaks to the 14th Amendment's spirit. Because what is the spirit of the 14th Amendment? It is political equality inherently. It is a restoration of the Constitution's guarantee that each state will maintain a Republican form of government. But that's what we can read and sense and feel in the 14th Amendment. And yet we are left with, well, what do any of the words in any of the 5 sections even mean? The Hotchkiss selections, I think, help us better understand that. Because at some point you have to write something that is not specific, that does not shoehorn people, because this is an amendment. You have to get 3/4 of states in an incredibly diverse, politically diverse republic to get on board. But what we all know in a diverse Republican system is what equality generally feels like, right? And that's what the 14th Amendment speaks to without being specific. And yet we are left over the next 150 years with a huge mess on our hands trying to give definition to this very vagueness. But the emptiness, the ambiguity, the vagueness, it was on purpose. Because we're also dealing with whom here? We are not dealing with legal theorists. We are dealing with politicians, and we are dealing with statesmen, again, who are drawn from the antebellum, anti-slavery tradition, political tradition. And that's what they're thinking about. They are thinking about imbuing principle into the Constitution, and they're thinking less about judicial doctrine. And the courts will certainly have a say in this.
Well, we have a moment of disagreement. This is gonna be great. I mean, and I'm not really in position to argue against the book because I haven't read it, but I did write the title down. And so what I think I think there are 2 questions that we should separate when we think about this. One is the question of authority, and the second is the question of the substance of the standards. What Hotchkiss is talking about when he talks about the Constitution should have their provisions so plain that it would be unnecessary for courts to give construction to them, he's talking about the question of authority, and he immediately dips into the question of authority. And he criticizes the first proposal for the 14th Amendment as like not granting the national government sufficient authority and access to the courts for violations of constitutional rights. So the next paragraph, after talking about the plainness of constitutional provisions, right in the middle of the paragraph, Hotchkiss says this: it should be a constitutional right that cannot be wrested from any class of citizens or from the citizens of any state by mere legislation. But this amendment proposes to leave it to the caprice of Congress, and your legislation upon the subject would depend upon the political majority of Congress, and so on. So like he wants to make the question of authority very clear. And he thinks that that Bingham's intention contradicts the proposal. So he wants to make that part clear. But the substance of it, I think he also wants to make clear, but like that's not the that's not the question that he's concerned about in this February debate, where he talks about the question of authority. The May debate is the question of substance. Like, the question of authority has been resolved. Now there's a question of substance. And I think the people who are deliberating upon the 14th Amendment and what equal protection means and what life, liberty, and property, not being deprived without due process of law, thought it was actually a very specific thing. And it was only after the Supreme Court, frankly, screwed it up in the Slaughterhouse case that we've had so much debate over the vagueness and emptiness of it. So I don't think the vagueness and emptiness of the 14th Amendment is intrinsic to the 14th Amendment. I think it's something foisted upon it by extraneous Supreme Court decisions. When you look at the substance of the 14th Amendment, and I think it's discussed best by this Michigan Senator, Jacob Howard, who, referring to a Bushrod Washington decision from the 1830s, Corfield versus Coriel, maybe it was 1820s, he just defines what the privileges and immunities of citizenship are. It's very nice. He says basically that all the rights in the Bill of Rights, well, those need to be applied to the states, and they need to be held to those standards. And then, there are other things that Bushrod Washington talks about. I'm just not going to get into all the details, but I think that it's basically the position of the contemporary left in America that the 14th Amendment is filled with vague generalities. And if you want to look at the 14th Amendment as completing the Constitution, as delivering on the promise of the Declaration, and you return to the debates, you see that the question of authority is pretty clearly defined, and the meaning of the provisions of the 14th Amendment are also actually very clear and limited in their scope. And it's only with the modern court that you get the penumbras and emanations from these decisions that make them into vague generalities. But I think you have to leave the debates and leave the text in order to get to that position.
I concede entirely to this point. That is I agree entirely with what you said, and I think that we just to add to this, I think what they're trying to do here is they are recognizing just how backwards these definitions of rights have become because of years of slaveholder interpretations of the Constitution. And so they're trying to give original meaning properly understood to what should have otherwise been very clear and consensual terms. But from Calhoun on to Jefferson Davis and everyone in between, these ideas have been so twisted and mangled that the Republicans are trying to unravel decades of misunderstanding to put things back in proper order. That's all I'll add to that.
Oh, what a fantastic debate. That was so good, guys. That was great. And you see, look, what part of the reason I love doing these webinars and working for Teaching American History is that, right, even when we disagree, we're still friends, and it turns out we probably agree more than we think sometimes. That was so good. Thank you for that. So you both mentioned the Supreme Court. So let's go to the Supreme Court next. Let's allow the Supreme Court to weigh in here, because the very first question that we got at the start of this webinar had to do with the Slaughterhouse cases. So what about the impact of the Slaughterhouse cases for understanding the purposes of the 14th Amendment? This individual specifically asked to please explain the importance and changes the Slaughterhouse cases made in the law for the everyman. If I could maybe put it, in a slightly different spin on this, according to the court, let me take that back. I'll just ask the question. Were the constitutional rights held by citizens of the United States now protected against violation by the states or not?
I'm not going to go first.
All right, well, I will. The Slaughterhouse case basically takes it all back. And the reasoning of the Slaughterhouse Case is that if we actually held the states to standards of protecting the privileges and immunities of citizenship, that would amount to a constitutional revolution. But no one called it a constitutional revolution at the time. Therefore, we are not holding the states to standards of privileges and immunities for all citizens. So, I mean, we could, I'm trying to explain this in a very layman's-like way, but we could go actually through the documents and show this for a second. So let me do that, and I hope this proves helpful to people. But let's compare the Civil Rights Act first. Let's look at the Civil Rights Act for a second. And I hope you guys have this in front of you, but this is just going to be a quick way of showing what the Slaughterhouse Case did, okay? So the Civil Rights Act follows the format of the 14th Amendment, all right? Now, this is something that like very few people recognize, but it's really important. So if you look, part is the second sentence of section 1. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. And then there's the due process clause, and then there's the equal protection clause. Now flip to section 1 of the Civil Rights Act, because the Civil Rights Act lists the civil rights. And it does so in a way that says, here's the privileges and immunities, here's the due process, here's the equal protection, okay? So look at the first paragraph of the Civil Rights Act. So, you know, forget the first 3 lines of it, but every race and color without regard to any previous condition of servitude or involuntary servitude, except as punishment for crime, which shall have the same right. These are the privileges and immunities of citizenship, okay? Have the same right in every state or territory in the United States to make or enforce contracts, to sue, be parties and give evidence, to inherit, purchase, lease, sell, hold, or convey real and personal property. Those are the privileges and immunities of citizenship. And then it talks about the process. Then it talks about equal protection. It follows exactly the same format. And what the Supreme Court does in Slaughterhouse is to say, wow, if they meant to give, if they meant to protect all of those rights, the right to have access to the courts, the right to have property, if they meant to protect all those things, like that would overturn our whole system. So they mustn't have meant to give all of those things. The Slaughterhouse Case, I think the key line here is, I don't know how far along it is, and I think you guys probably have a PDF, but it's in Justice Miller's decision, you know, like six or seven paragraphs before the end. They say this: the argument we admit is not always the most conclusive when it is drawn from the consequences urged against the adoption of a particular construction of an instrument. But when, as in the case before us, these consequences are so serious, so far-reaching and pervading, so great a departure from the structure and spirit of our institution, when the effect is to fetter and degrade the state governments by subjecting them to the control of Congress in the exercise of powers heretofore universally conceded them of the most universal and fundamental character, when in fact it radically changes the whole theory of the relations between state and federal governments to each other and of both these governments to the people, the argument has a force that is irresistible in the absence of language which expresses such a purpose to clarify, to admit of no doubt, to admit of no doubt. So anyways, like that's what the Slaughterhouse cases do. It says, wow, it would have been really important if they, if the 14th Amendment changed the relations between the state and government, and like, we don't like that, so we're not gonna do it. And it takes back a lot of those privileges and immunities and narrowly defines the privileges and immunities. So basically it has no effect on how the states operate.
I don't have much to add to that. That was spectacular. But
I went on a rant. I went on a rant, but
no, that's good. I have rants too, so I definitely understand. I just wonder. I'm not trying to revive the ambiguity argument. I guess I'm trying to revive the ambiguity argument a little bit, because I'm now entirely convinced by Scott's explanation of how clear the intent was from earlier. But I do wonder if Slaughterhouse is an indication somewhat of how privileges and immunities, at least in the text of Section 1, can be read as here's one interpretation, here's another, even though we instinctively know, and we can go back to Coriel, we can go back to Coriel and understand, we can look at the Constitution and understand what privileges and immunities are. But I wonder if Slaughterhouse is not an indication of the consequences of not spelling it out. Or if Slaughterhouse is just what the Supreme Court does and begins to rewrite things as it sees fit. I'm not sure. This is a question I ask my students. And I've been thinking about it the last few days in preparing for this.
So we should just talk briefly about what the facts of Slaughterhouse are. That Louisiana basically made someone's like slaughterhouse unprofitable by granting monopolies to other slaughterhouses. And the people who lost their slaughterhouse or the value of their business said that this was taking property. And one thing the court could have done is said this: you're right that the state cannot take property away, that they cannot grant monopolies so as to deprive people of their genuine property. They can the states cannot decrease the value of it through their regulations. But this case is too much of an extension of that principle. So forget it. But instead, what the court said is, oh yeah, you say that your property's lost value, therefore the states can never regulate property, or the states are free to regulate property however they want. They could have had a moderate, you're right, this holds the states to standards, but this is taking that standard too far. But instead they just swipe away all standards. And so I think there was a moderate approach that was available to them, and I might have signed on to that opinion. You never know. But the decision blows away the mosquito with a bazooka, and then puts a bazooka hole right in the Constitution.
Yeah, and in a roundabout way, I think unintentionally, it adopts some of the oblique logic left over from Dred Scott in 1857, insofar as it creates from the bench of the Supreme Court where citizenship derives from. And in Slaughterhouse, we're left with this bizarre notion that we all have two legal citizenships, right? Citizenship of the nation and citizenship of the state, which I love explaining that one to my students, because that right there, their first question is, oh, okay, so now I see legally how we get to Cruikshank, and especially Plessy versus Ferguson in 1896, which are entirely based on notions of national citizenship and state citizenship, which cannot be at cross purposes. And how the court, I'm not a legal historian, I'm not a court historian, but that's the part of Slaughterhouse I admit I've never understood, how they were able to get to that logic, which then blows up this entire enterprise.
Oh, see, now let me just respond to that, because we might be in disagreement on this too. I think the dual citizenship thing is true. We are citizens of one state. We can vote for our state legislators. We're subject to state laws. We can help make state laws, but we're also citizens of the country. The backstop theory of Reconstruction is based on the idea that we have dual citizenship. We are citizens of states. The states can do their job properly initially, but if they don't screw up, we're also citizens of the country, and rights adhere to those citizens. So I think here's something that you don't hear on an Ashbrook seminar very often, but Dred Scott gets that right? That we are dual citizens. And I think that Slaughterhouse is right to say that we're dual citizens. The whole theory of that this is not a revolutionary change in government is based on the idea that we're dual citizens. It's just that it offers such a thin understanding of national citizenship that that it ends up gutting the whole idea, and reviving that idea takes, you know, like 100 years.
That's actually really clarifying. I appreciate that.
So
Yeah, me too. Yeah, sorry,
Jason,
Scott, go ahead.
we need to do a seminar in praise of dread. That'll be a big winner.
We'll have to take that one under advisement. By the way, you gentlemen, you just answered like 3 or 4 questions that we had coming in about getting the facts of the Slaughterhouse case, summarizing Miller's opinion, the makeup of the court. So you've pretty much answered several of the questions already of our audience members, but we've got one more question for you because we're quickly running out of time. We're down to our final 3 minutes, so I'm going to have to ask you both to be brief on this. I know these webinars, they always fly by. So we've got a question coming in about the last document, Frederick Douglass, and his talk, "The United States Cannot Remain Half Slave and Half Free," from 1883. In this speech, Frederick Douglass at times sounds very pessimistic, and at other times he sounds extremely optimistic. Why is that? What are the sources of his pessimism? What are the sources of his optimism?
I'll start by saying briefly, read anything that Frederick Douglass wrote in the first 5 years of the 1880s. And it's the same theme all the way through. I would add, read his speech from 1880 called West India Emancipation, which is actually way more pessimistic than the one under review here, because he's looking back at the whole Civil War era and recognizing that there were 2 wildly different interpretations about how to conduct the war, what it was about in the minds of white Americans versus Black Americans. And that's what he's dealing with here in his own House Divided speech. I think that I'll start with the optimism, but it's also rooted in the pessimism. I think that Douglass understood the inherent logic of what Lincoln was saying in the House Divided speech, because it's not simply having a geographical division between free states and slave states. It's an intellectual and a moral division between competing claims to truth. Are humans innately equal as humans, or can humans be reduced to property? When you have an argument, a moral and an intellectual argument rooted in that kind of conflicting claim to truth, then the House cannot be whole. And that's what I think Douglass is dealing with here. He's actually speaking implicitly that there's a kind of blasphemy that's still continuing in the American body politic, that still claims that some humans are superior to others. And he's saying, no, that is objectively, it can't be true. But there are some Americans who insist on it. And how we undo that is a matter of time, because he also says toward the end, there is but one destiny, right? At some point, we're going to get this right, because truth can't be concealed forever. That's what Lincoln was saying too. But we can also go backwards so easily. We can roil ourselves in contradictions. I'll leave it at that.
I see we're out of time, but I'll just say very briefly that I think he thinks the original understanding of the 14th Amendment reflects the Declaration, and that the people of the nation are the people of the Declaration. So the condition of Blacks will bother Americans.
All right, one final note to take us home, gentlemen. Andy, I think you already did this. You have 5 seconds to recommend 1 or 2 books that you think would be useful for our audience to read to better understand this topic.
Certainly the Nelson book, and I will also recommend, as a primer on Reconstruction, Alan Gelzo's great brief book called Reconstruction: A Concise History. Gelzo's fantastic. This is the book to read.
And that's really a book. I read that book. That's the Reconstruction volume from Gelzo. It's awesome in many ways. One of the great ways that it's awesome is how it's accessibility, right?
Absolutely.
It's comprehensive and yet accessible, and you can read it in 1 or 2 sittings. It's a short book. Scott, totally. Any recommendations from you?
Getting it from my shelf here. I mean, I think James McPherson's book, The Struggle for Equality, is good. And there's an endless number of books on Reconstruction, and I don't want to say that that's the best, but I do think Eric Foner's book, Reconstruction, is probably the best, even though I don't like the framework over much.
I'll recommend this book on Reconstruction. Gentlemen, thank you both for joining us. Thanks to our panelists, as well as to our participants for some great questions this morning. As a reminder, within the next week, you will be receiving an email that will include links to today's readings, suggested further readings on today's topic, and a link to the archived webinar. We hope you will share this information with your colleagues as well as on social media. If you enjoyed today's webinar, please consider taking an online graduate course in our MAG program, our Masters of Arts in American History and Government program. Both Andrew and Scott teach in that program. They have for years. You can find more information about our online course offerings, as well as many other resources for teachers at teachingamericanhistory.org. It's a fantastic resource for, especially for teachers, but really for teachers, students, citizens, all Americans. This is our second episode of American Controversies. Our program will return in a few weeks on November 5th, when the discussion will turn to federalism. We hope to see you all then. Thank you again so much for being with us. Gentlemen, Andy, Scott, thank you both for being with us this morning. It's always a pleasure. And we'll look forward to seeing you all with us here again. Gentlemen, thank you very much. Audience, thank you.
Thanks very much.
Thanks.
Thanks again for listening to Teaching American History's webinar on the 14th Amendment. For more information on our webinars, in-personal educator professional development programs, free document library, and graduate program, please visit us at tah.org.